Welcome back to our special report on Indigenous land rights. This next story is not related to the Cowichan ruling or the Musqueam agreement, but it does involve Indigenous land. Back in 2021, residents of the E. George Estates manufactured home park in Saanich, BC, were given a 3-year notice to vacate their homes. The Songhees First Nation said it was looking to use the land to house members of the nation, and the evictees were not members. Well, this has led to a long, drawn-out court battle, and some folks now being left homeless. Joining me to explain is lawyer Michael Drouillard and one of the mobile home park residents, Dan Cernosky. Thanks to both of you for joining us today. Appreciate your time.
Absolutely, great to be here.
So before we get to the case and the court battle, Dan, just maybe describe for me life in the E. George Estates mobile home park prior to all this. What was it like living there?
It started as an over 55 community, and it was pretty pleasant. Everybody knew each other. It was quiet. People worked in their gardens, went for walks around the gorge. It was a pretty laid back, quiet type area.
So would this be considered a community of retirees for the most part?
Well, 2 years before this happened, they opened it up to 55 below people, but up to that point, it was a 55 plus community.
So in 2021, you received an eviction notice. How surprised were you? Do you have any idea this was coming, or were you just completely caught off guard?
Well, we had purchased just the year before, and there was no mention of any of this when we purchased. So we were quite shocked. And the whole idea that you have to leave, and also if you don't leave, if you just walk away from your unit, we're going to charge you $20,000, was a big shock to the residents, because a lot of the people were retired and invested their life savings in the community and had frankly nowhere else to go.
So Michael, explain this to us now. How is this case different from the Cowichan ruling or the Musqueam agreement? What was at play legally in this case?
Yeah, so in the Cowichan case, for example, that involves an Indigenous nation seeking a claim of Aboriginal title over a specific tract of land that's not part of that Indigenous nation's reserve. This is quite different because this land is and always was part of the Songhees Nation reserve. And also, because it's part of their reserve, the Songhees Nation has the direct authority to manage these lands, which is very unlike the Cowichan context, because in Cowichan, you could have a finding of Aboriginal title. That doesn't mean that the Indigenous nation has any particular say of those lands just because there's been a finding of Aboriginal title.
But in this case, the certificate of possession, I believe it's called, changed hands, or what happened here?
Absolutely. So this park was originally established in the 1970s, and it was owned by a band member. Then in and around 2019, the band member's interest in this park, the certificate of possession, was sold to the Songhees Nation. And the Songhees Nation purchased the lands with the intention of redeveloping it, which is really unfair to Mr. Cernosky's family, because they bought into the park after the Songhees purchased it, even though the Songhees knew that they were going to redevelop it, yet they let folks still buy significant property interest in the land, knowing that they were going to make everyone leave.
And these, they had signed, I believe the tenants or the residents had signed agreements, and they were paying fees to be there and so forth, like they had been paying the First Nation?
That's a good question, because, and this is another criticism I have, is no one had signed written tenancy agreements saying that they had only a limited right to be there and that they had to move out. However, when the Songhees made the decision to evict, they gave these tenancy agreements to everyone, telling them to sign it so on the basis that it would secure their interest in the property. But in reality, they were making the residents promise to also remove their homes and getting other obligations from them that they were not normally required to give. We actually called these agreements unconscionable and unfair to the court. And in essence, they tried to do that, but fortunately, most of my clients didn't sign those agreements.
So Dan, you get this eviction notice, and I'm assuming in the mail or in your mailbox, and you read this thing. Did it make any sense to you? Did you, or just completely caught off guard and you were just completely unaware, considering you said you bought just like a year earlier?
Well, as part of the process, when you buy when you bought into Georgia States, you had to go and meet the family and shake hands, and they welcome you to the family. So it seemed like a very friendly type environment. So then to get these, it was an absolute shock to the people in the park. Within the first week, we had a meeting with the whole group, and we decided to go forward because it didn't seem ethical or fair. So we had a whole meeting, and we kind of decided that we are going to do a class action kind of thing on the lawn with lawn chairs, and my daughter took the notes, and it was a fairly lot of stunned people.
Yeah. So, Michael, you decided to help these homeowners pro bono. Give us kind of, I guess, the short version of what's happened in court, your case, and maybe an update of where we stand right now.
Right. And just to clarify, I did do the appeal pro bono. I did the lower case, what I'd say low bono at a reduced rate, where in essence, my firm, we have a unique background both in Aboriginal law and manufactured housing law, which is a strange combination. And when we heard about this case, we kind of felt that we had to do it because there was no other law firm that could help them that had that unique background, and that it had never been done before. And it ended up being quite a monumental task because of the complexities of the law in this area and in the managing the many difficult stories of our clients. Dozens of people were affected by this and were our clients. So it ended up being quite a large undertaking. And it went all the way to the Court of Appeal.
And you lost the case in terms of people being able to stay in the park, but you appealed. Correct? You appealed part of that decision?
Absolutely. So what happened is we sought an order in the Supreme Court, BC Supreme Court, that the residents should be permitted to stay another 10 years. And one of the reasons why is because there was evidence that although the Songhees intends to develop the property, they actually don't have any specific plans right now. And it could be many years before the property is actually developed. So we said, well, it'd be fair to just have them be able to stay another 10 years. We were not successful, but then we appealed specifically the finding that they had to remove their homes and that they were not entitled to compensation for them. Unfortunately, the Court of Appeal agreed that there was no legal requirement to remove these homes if a resident didn't want to, which is great because, as Mr. Sinofsky pointed out, even if you just demolish the home, it's a tremendous financial burden to have to do that.
So what happens with those homes? They're just sitting there now, or the First Nation will deal with them, or what'll happen to them?
Presumably, and in that regard, it's really too bad because we understand the nation had an immediate and urgent need for housing, including some folks needing it on an emergency basis. And what typically happens in a manufactured home park is the owner might negotiate with the residents, maybe do a buyout, and there was an opportunity for this to be done. And it could have been a win-win situation where the Songhees gets housing for its members who urgently need it without my clients having their life savings taken away from them. But because of the aggressive litigation, we're now in a situation where my clients have lost their life savings and the Songhees don't even have housing for their members. There are now this graveyard of manufactured homes at the park. And it's going to be very expensive and costly for the Songhees Nation to remove them when they could have been housing.
So Dan, what's your current situation? Where are you living now?
I live up in Cowichan Bay in a house with my wife. And my daughter is currently renting a room. Unfortunately, from her perspective, she still has to pay off. We still have to pay off the mortgage, and yet she has to pay rent to live and work in downtown Victoria. So she's looking at possibly moving out of the province, which is a shame because she's my favorite person. And she's looking at maybe having to move out of the project, pay off the mortgage and then move to another province in order to be a homeowner again.
Right. So it was your daughter that was living in the mobile home park?
It was.
Yeah. So how do you feel about it? How's she feeling about all of this?
She was devastated by the whole thing because here's a kid that did everything right. Like she went to university, paid her own way. She worked 3 jobs to pay the mortgage down. She's a bit of she's an environmentalist, so she bought a new heat pump for the house, not having any idea that it was going to be taken away in a matter of months. And she put a new heat pump in. She was paying the mortgage down. She worked 3 jobs to pay it down as much as she could, and then all of that. Not only is the equity gone, also she still has to pay off the mortgage. So it seems a little unfair. I'm a little outraged.
Yeah. So Michael, going forward, you've explained how this case is different than Cowichan or Musqueam, but is this a bit of a precursor of what might be to come in the future for some landowners?
Well, one of the unique things that you find in this Indigenous context that you don't really see outside of it is a circumstance where, in this case, the Songhees weren't just the landlord, they were the lawmaker, the tax assessor, all of these things to the residents. They had the power to make laws that regulate this issue. And it really, in my view, creates a potential for a conflict of interest where your landlord is also the one who creates the laws and can create tenancy law. For example, the Songhees Nation passed a residential tenancy law regulating regular residential tenancies, but they didn't pass a law regulating manufactured housing tenancies. And so this creates a question of, well, why is that? And one of the concerns I have is that they're not incentivized to create regulation for manufactured housing, because by having no regulation, it means they as landlords have all the rights and can evict without giving compensation. And so I think we're going to see more of these types of cases, and in my view, more risk of this conflict of interest where First Nation is both managing its lands but also owns it and wants to do things with the land. And in that regard, tenants of reserve land are probably the most vulnerable tenants in Canada, even compared to regular tenants, because at least regular tenants are protected by provincial laws like the Manufactured Home Park Tenancy Act.
Yeah, so much at play here. I appreciate you both joining me for this interview and just giving us your sense of what's going on there. Michael, Dan, thank you for being with us.
Thanks for having us.
Michael Drouillard is a Vancouver lawyer. Dan Cernosky is former resident of the E. George Estates Manufactured Home Park near Saanich, BC. Coming up, retired Judge Brian Giesbrecht weighs in on these land rights cases and what we might see on the legal horizon. Stay with us.